be talking about really how to handle when you have a potential real estate investment. So we're not really talking about your primary home, though that is a sort of investment too, because it does have value and that value grows. But we're really going to be talking about second homes, broader investment properties. What are we supposed to be doing with them? Specifically, there's a lot of different layers of what you need to look out for, but we're going to be looking at it through the legal lens. I am an attorney. I'm a licensed attorney in the state of California. I've been working as an attorney here and I've been counseling businesses, small businesses for almost 10 years now. I specifically work in our business tax and advanced planning department. So I work with also skilled specialized tax attorneys too. And a lot of this content comes from their expertise as well. Okay. And if I didn't introduce myself, I would like to say, because I think I might have jumped the gun, my name is Katherine Grout. And I head up that business tax and advanced planning department alongside several other attorneys and paralegals. So lots of names that you'll see. We also have at Copenbarger a very large estate planning and trust administration team, which we're actually going to look at in a moment. So many faces, and I'll point it out as we go if you're not familiar with our firm yet. But before we get started, as I was mentioning before we even started the webinar officially, this is all going to be general knowledge. It's educational, it's general, it's meant to be the jumping off point that you then take to your legal counsel, your attorney, your accountant, your other tax advisor, whoever is helping you to really create the plan that's unique to you. Because a lot of this, I'll speak at it from a very general lens, but there's a lot of nuances that could come up. So I'll try and stay pretty high level, but also point out that there's complexities that we need to consider. Okay, so this is not the end of the road, this is the beginning. Okay, and as I was mentioning just a moment ago, our team's actually pretty big and it's been growing if you're familiar with a firm. So we have several faces on this screen, primarily our attorneys and our executive leadership, our partners. So you'll see myself, Kevin represent the business tax and advanced planning department down at the bottom. We have a whole team with us. We also have a separate estate litigation department that can handle if you're in any murky waters or any disputes or any issues. It's really great that we have actually a litigation team with us that we can directly fold in whenever you're encountering any problems. We hope it never gets to that. That's what our planning is for. So you'll see at the top row here, primarily represented are the core estate planning, where you begin your journey when you're looking at preserving your legacy. Then the middle row, we also have our superb estate administration team that handles actually what happens when we need to implement the plans that you've created once you've passed away, or perhaps your parents have passed away and now you're trying to deal with what's supposed to happen. That's our entire estate administration team. A great group of people, but not all. We also have a huge support staff full of legal assistants, paralegals, plenty of people that help us keep the ship running, help get your questions answered, help support you and your needs timely and efficiently. And a little more intro for the firm, if you're still not familiar, I just want to point out, so we're a California-based firm at this point. This firm has been around for, well, almost 50 years now. We're past the 45 mark. I think we're at about 47 maybe. We have been in other states in the past, but right now we're really honing in on California. We have plenty of locations to support California clients. That said, a lot of what I talk about is actually not just California based, because you might have property outside of the state. So do keep that in mind. This content today is not limited to California. Okay. I'll try to talk about it more generally. There's going to be laws that are specific to California, but if you have out-of-state property, or if you live out of state and have California property, this content's going to be relevant to you, okay? So we do have locations in Northern California, the Bay Area, also Sacramento, and then most of our 5 other locations down in Southern California. Currently, I'm out of San Jose. I'm up here most of the time, but I do frequent our main office at South Coast Metro in Santa Ana. Okay, that was a lot, and that was really just the intro to the firm. But I'm going to try and get right into content as well. So, as I mentioned at the very beginning, we're looking at asset ownership, liability protection, tax considerations, and future plannings that are specific to the investment or the asset of real property. So, second homes, commercial, residential, whether or not it's rented, whether or not it's just land, doesn't really matter for today's purposes. All of those types of land use and all those types of zoning, that's all going to be applicable to a lot of the content that we're discussing today. But we're really just looking at real estate assets right now and how to deal with them when either you've inherited them, or maybe you've built up enough of a portfolio of assets and you're deciding to acquire a second property, a third property, a rental property on your own. So all considerations for today's content, but really that's the scope. All right, now let's dive into it. So we're looking at, as I mentioned, the asset of specifically property. So let's talk about a little bit about when you might get these milestones and when you need to start thinking about, do I need to start acting? Do I need to start planning from a legal perspective? So whether or not, if you anticipate that you're going to inherit property soon, that's a really good moment to pause and say, how can this be inherited best for me, best for who is gifting it to me, sort of in my inheritance, my parents, whoever is, however I'm acquiring the property. It could be commercial lots. Maybe your parents currently own a commercial lot, or garage that's rented out to a business. They have tenants. It's an existing establishment, or maybe they are just in a home. Excuse me. They're just in a home, and you know that you already have a primary residence. You don't want to go move to wherever their home was once they pass away, but you do want to keep that investment, and perhaps you want to start renting it out. Perhaps you want to start using that investment as a rental property, or maybe you don't want to keep it. These are all things that you need to start considering when you're looking at, what do I anticipate will be either acquired, transferred, I will buy, or I'll inherit in the near future as far as property. So, okay. So when we're looking at, actually, I've covered, so we're still talking kind of broad strokes, because we need to start thinking about, okay, what applies to me? When do I need to start considering some of these concerns, some of these liability exposures, or when do I need to start setting myself up to get the most advantageous tax treatment once things actually start transferring? So we're going to be talking a bit generally, but trying to cover all of that scope today. So you want to start thinking about, do you want to rent this property that you're acquiring? Do you want to, or is it solely just an investment that you want to hold somewhere right now? Is it going to be a second home for you that you then don't want to rent? But there's still lots of considerations and liabilities on the property that you want to consider. Then you'll also need to start thinking really early on, and before you even get the property, about, when it's transferred to me, what are the taxes going to look like, depending on how we plan ahead for this. What we're concerned with, property tax, and then we're also concerned with transfer tax. We're concerned with capital gains tax, and whether or not you can get a step up in basis on that asset to avoid a capital gains tax or a large capital gains tax if you then turn around and sell that either inherited property or acquired property. So all things that we want to plan for. You'll want to think about, for example, if you anticipate inheriting a property soon, you'll want to think about the character and nature of the property. Do you want to just flip it? Do you want to just get rid of it? Do you want to liquidate it? Do you want your children to have the option? Do you want your children to acquire it? Do you want your children to manage it? What things, and maybe these are also family discussions to have, sit down with your children. What are their goals? I know I had this discussion with a couple of generations in my own family recently about a single family home that's still in our legacy. And it is interesting the assumptions that I made about what others would want to do with the property. And those assumptions were probably 50-50 correct and incorrect. So really, I do encourage people to have open discussions to the extent they can. You know, there's a lot of different personalities that come to play in family dynamics. But to the extent that you can, at least understand what people's motivations are ahead of time so that you know what type of planning you can get in place. Now, so how you acquire, we're still pretty broad, how you acquire that property is really going to impact how you can move it, how you can convert it. Um, we will touch on Prop 19 and what that means with respect to LLCs now that with respect to LLCs and non-primary residents, because that's really the kicker here, is that under Prop 19, now we really can't include these second family homes. We really can't just include any properties or at least the broad scope of properties as before. We're really just looking at the reassessment for the direct single your primary resident, your parents' primary resident that you may then want to acquire and make your primary resident. We'll get into that then because there are specific rules related to what we're thinking about with these second homes, these investment properties, and whether or not we put them into an LLC or not. But we'll get right into that in just a moment. So I want to just take a moment. So let's say you acquire a property today, tomorrow, the next day, very soon, and you know you don't want it. You know you want to sort of liquidate it. Depending on how you acquired the property, it may be okay if you inherited it and you got to step up in basis, and it may be more advantageous to flip it right away versus or sell it right away versus holding on to it and then having that capital gains sort of that value appreciate and have a capital gains tax. However, we really want to stress, please consult both financial advisors and legal advisors before you start pulling the trigger on a lot of these decisions. Because once you start to act, a lot of times it's very hard to get out of that plan. Once you start the plan in motion that you've created, maybe without adequate advice at the forefront, it's really hard to walk it back and sometimes not possible. So sometimes we have clients come to us, they've done something, and at the stage that they come to us, it's kind of we have to take them at face value and say, realistically, we can't help you with this now reassessment that you have. We can't help you with this. You've kind of gone too far. We'll try our best to figure out if there's any solution there, especially when mistakes are made, but it's often very challenging. So what we would like from you is for you to come to us, have the discussion early on, set the plan in motion before you start taking action. That's just my plug to save you in the future. Okay, so now let's get into liability protection and sort of what I've been alluding to most of this presentation so far, which is this LLC structure, right? So I'm going to talk about LLCs broadly. And then I'm also, but specifically, I'm trying to look at them through the lens of rental property LLCs or property management LLCs. So a couple of different things we're going to talk about in this capacity. Don't get too in the weeds. We do a couple of other webinars, and we can, they're in our library of webinars. We have some that are specific to businesses, entities, entity formation. So if there is something that you hear, you want to dive a little bit deeper to understand some of the regulations around a business entity itself, that's something that you can cover and go over in a previous webinar that we recorded and possibly future webinars. But right now, we're going to try to limit the scope to really just the bullet points that would apply to someone who has a rental property who is taking advantage of this vehicle of a limited liability company to eliminate or mitigate their personal liability. So let's talk about what this is, why we're even doing it in the first place. So there are, without getting too spun out, there's many different types of business entity types. There's two in particular that have this legal concept called the corporate veil. It's a limited liability. There's two in particular in California. Everything I say almost just imagine a little asterisk next to it. So there's two main ones, I'll say. There's the corporation, sometimes referred to as a C corp, but that's really tax classification. And then there's the limited liability company, which is somewhere in between just running your own business or running your own business with a sibling or some other person, a partner. So that would be, your sole proprietorship and your partnership. This is a step up in the formation of a separate legal entity, which adds a little bit of complexity and therefore creates this shield. So a limited liability company, an LLC, has the same protections over its owners that a corporation does. So when we think about what a corporation looks like, the owners of that business or the shareholders, the managers or operational arm of that business are generally the board of directors, maybe the C-suite. When we're looking at it in the LLC terminology and lens, the owners of that LLC are members, and the managers are the operational people. They would be the board of directors or the C-suite. Those two people in an LLC can be the exact same thing. They can be the same thing in a corporation too, but oftentimes, especially when we're talking about these more simplistic LLC structures for rental properties that are really focused on creating that personal liability protection, we're looking at simple structures. It could be an intricate web of simple structures, but fundamentally, they're simple structures. It's especially who I work with, it's families that have a second home. It's spouses that go into either they inherit or they have a second home and they want to rent that property out, but they also don't want to have liability exposure over their other investments. Maybe they have other investments that are other properties, or maybe they have other investments that are liquid assets, stock, any number of things, significant assets, that if there's a liability around them directly, then those assets are at risk. So why we look at this corporate veil structure is because there's a lot of risk and there's a lot of unknowns around property. Okay, so let's take a couple of real examples. So there could be conditions on the property itself. It depends totally on the nature of and the characteristics of the property. But for example, I know we had our litigation department, and Elaine was working on a case where there was an exploded septic tank that caused massive destruction. That type of destruction can also cause liability and damage to adjacent properties, then you're looking at that tick, 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 that liability just racked up millions and then millions. And then depending on some of these property values and exactly all the scope of the damage that could be caused, it's it, we could spiral out here. So think about, okay, what's the nature of the property? What are some of the conditions of the property that could cause risk? They could be features or installations like a septic tank, or maybe even they're not on your property. Maybe they're on the neighboring property and you're on a slope and something that the neighboring property did. I had a client recently who one of the neighboring properties decided to set up a horse ring and an entire barn and really use their land for a lot more than it's actually allowed and zoned to be used for. And then it causes all of these issues with runoff or lack thereof, or instabilities, things seeping into the ground. There are plenty of risks and then plenty of dollars that can either be attached to you as a liability, or that you could try to seek out from someone else. Um, People are doing plenty of creative things, especially with investment properties. I know plenty of people do now like yurt campgrounds and have frequent tenants. Maybe they are more like Airbnb or short-term rental tenants. Maybe they're long-term. Typically, we associate longer-term renters as treating the property a little bit better, but with some of these investment properties where perhaps they're a little bit more rural, they've set up, an Airstream camp or something where they're really churning out plenty of short-term tenants. Lots of liability with that. Lots of opportunity to have some of these legal claims, lawsuits, anything could happen. So we're really looking at any number of things. If you're fortunate, none of this ever happens to your property, right? But why not eliminate that risk when we look at, okay, what is the cost to eliminate that risk? So what does it cost to create this LLC that creates a shield around that type of liability and risk? So what the LLC does, I like to sometimes think of it more as a cage. They call it the veil because it shrouds over. Um, but really what you're doing is you're covering the personal assets of the owners of the business. So you're trying to draw a line or put a cage around this this property and all of the risks associated with it. So we are essentially creating a shield that then means that if there is a liability, if there's a lawsuit, creditors, some issue with the property, the rental of it, some other element about that business, that liability or that lawsuit cannot penetrate your other assets. That's the line that we're drawing here. So then we look at, what does setting up an LLC look like? What's going to be the cost? Here, I also want to mention, we'll probably get to this later on because I want to save you some time in your evening. But insurance, definitely great. Doesn't always cover it. Also, when you're looking at any insurance policy that may cover your business or your rental property, just remember that you're relying on a contract that someone else wrote that you couldn't negotiate, and that they're going to say whether or not you can enforce it. So you really lose a lot of protection by just relying on insurance, because they are not incentivized to really grant that. They are not incentivized to help you as the insurer when there is an opportunity in the contract that they created for you to not have to have that economic obligation to you. So, and I would be cautious to rely on insurance alone. I always say both. Both. You want umbrella insurance, you want some sort of coverage for you, your business, your property that you're renting out, or whatever you're doing with this property. And then you also get the benefit of this LLC protection as long as you're okay with the costs of it. So let's talk more about what does it look like to set up those costs too. And we've talked a bit about this. I'll come back to living trust now, or in just a moment. So we talked about umbrella insurance, and we talked about some of the structural considerations of LLC protection with the concept of member and manager. Um, but I do want to, I'll come back to that because there's more content later on that kind of addresses it. So let's talk a little bit more about some of the obligations of an LLC structure and what that looks like. Let's just like dig in a little bit more. So I was mentioning members are the owners that share in profits and losses of the LLC. Managers are the operators or literally managers, or they're akin to the board of directors or the C-suite executive team. Um, Typically, what we'll do is set up or commonly, I should say. There's always plenty of room for variety, which is part of the benefit to an LLC, is that we can really create creative structures. Um, but typically, let's say you're a married couple, and you have a second property, you're going to be members and managers. So it's a member managed LLC, very straightforward. But let's also consider there's plenty of other ways to go about doing this. So let's say, um, actually, and let's also talk a little bit about how that's treated from a tax perspective too, before I get too far in. So if it's really simple, if it's just you owning the LLC wholly, sharing all of the profits and losses are just directly you. The IRS treats you as a disregarded entity. If you're a spousal unit that files your taxes together, same deal. So you'll be treated as basically just a disregarded entity. Your taxes are almost the exact same. If, let's say, you and your sibling inherit a property and you own it now 50-50 with your sibling, you're running it as a rental property, you've put it into an LLC, how is that LLC going to be taxed? So for that case, it's going to be taxed as a partnership, which is pretty similar. Profits and losses flow through to the individuals, but it's a little bit different because you'll have a K-1 and you'll have to go through separate filings like you're running a business. It's not treated as a disregarded entity anymore. Um, Lastly, there's another consideration as far as the structure, or a last main consideration, and that's registering your LLC as an S corporation. Typically, it's not going to be advisable for just solely a rental property LLC or just solely something that's holding that rental property asset. However, especially if you get a little bit more complex, let's say you have a couple of investment properties and then you create a separate LLC that is strictly for the operations or management, property management, that might be an occasion where it might be advantageous for you to register your LLC as an S corporation. These are all very, these are all very from my perspective, it's fairly straightforward, but I understand I don't want to get you too far into the weeds. You really should just consult with your tax person, your financial person, or your attorney, or all of the above when trying to walk through how many properties do I have? What structure do I want them to have? Because another question that I get frequently is, I have a couple of properties that I rent out. Do I put them all in one LLC, or do I put them in separate LLCs? It's going to be a cost benefit analysis to every person. But the benefit of putting them all in separate LLCs is then you're isolating all of that liability to that one lot, that one property. So if something happens to one property, it shouldn't impact the other property. If you have a very complex structure and you're truly operating this as, you're really getting into property management as the business itself, then you may also want a separate LLC for just the management. And that LLC might be taxed as an S corporation, for example. And S corporations will receive certain benefits because they can take advantage of creative deductions and creative planning from a tax perspective. So something to talk about with your tax and finance person, and then in conjunction with the attorney setting up the planning for you. So I know we're going over a lot. I'm checking my notes to make sure that I feel like I've given you the information that you need from this portion, and make sure that I don't skip too much. One other thing that I guess I'd like to touch on is also just, as I was mentioning at the top of this slide, the ability to creatively structure your LLC. Going back to the concept of member and manager, member being the individual who owns, or individuals or entity who owns the business, and then manager being the more operational head, you have the flexibility. You can make that the same person. You can run and own your business wholly. Or if you, for example, even if you have a child who has no ownership interest in that business, you can then make them a manager if you want them, for example, to manage that business for you. There's other considerations too, like do you want to hire them as an employee? If we're really looking at that property management, you're really building out this business and incorporating property management using your children. Yeah, terrible choice of words, but allowing your children the opportunity to learn business through managing and property managing better, then you can hire them as employees, or you can make them managers of the business, or some combination of the two. So there are different titles, different roles, different responsibilities, different levels of duty too. All things to consider. And all things to consider with the full scope. Here we just have sort of more of let's look at what types of properties are good for LLCs. Almost all of the above. Basically, just not your primary residence, because I say to clients, what are you protecting? You're just making an obligation, because now you've put your primary residence in this cage that then has liability around it and is still subject to, you're not saving anyone. So generally, no on the primary residence, but basically any other property, whether or not it's rented, whether or not it's just, sitting as an investment, whether or not it's a short-term rental, long-term rental, commercial, residential, multi-unit, all of these types of things, perfect to be considered and put into an LLC. Now, I know I said this a couple slides back, but let me actually get into a little bit more of the cost of an LLC. So what are we looking at with license, registration, costs, actual flat costs? What do I need to do from a corporate governance perspective? So first off, you're going to register and organize that LLC in a specific state. I almost always, there are very limited exceptions, recommend clients to organize in the state where the property is located. Because first off, you're going to be, if you got to go to court, it's going to be in that state. Second, You're going to have to, because you're operating the business in whatever state that the property is actually located, more than 9 times out of 10, you're going to have to register in that state, regardless of whether or not you form in that state. So typically, wherever the property is located, that's where you should form your LLC. If there's multiple LLCs, then we need to consider, okay, or there's multiple properties, then we need to consider, do we want multiple LLCs that are from different states, or do we want an LLC in one state that is also registered to do business in the other state that holds both properties? Plenty of considerations, just depends on your situation and very specific cost benefit analysis, because all of these LLCs are going to have some sort of ongoing cost or requirements. Some states are very lax. Of course, I think you can anticipate we're in the state of California, less lax. Um, the California has what is referred to as the LLC tax or the LLC annual tax, several names. It is a flat floor $800 annual fee. It's essentially what we like to call the cost of doing business in the state of California. $800 annually is going to be a recurring fee in the state of California to have any LLC, whether or not it was formed, whether or not that LLC was formed in California. So there's really no way around it. If you're at all in California. You have, let's say you have a property in Nevada, you form a Nevada LLC because that's where the property is, but you live in California. Maybe you operate the property out of California, maybe you conduct business in California. You're going to have to register in California and you're still going to have to pay that $800 tax. Sorry. All considerations to have is we'll walk you through what the requirements are that are specific to you. I also want to be mindful of the fact that there could be local licenses. I typically recommend clients to check these out on their own, but we can certainly and have certainly helped clients register their businesses at both the municipal level or the county level. Depends on what's required, where the property is, where they're operating, and what business operations are actually being conducted out of that county. Typically, where the property is the definite what we need to look at as far as business operations, but sometimes there's other considerations too, like where the members are, where they live, where they're registering, that type of thing. So there may be some small separate licenses that are just localized requirements with small fees, but stuff you need to consider, or else someone's going to be mailing you demanding a bit of money. Okay. So a couple of other things before I move past this slide. So one thing we love about LLCs is that they have very limited statutory obligations. So corporate minutes that are mandatory, corporate meetings, all of these things that businesses have to do, not actually statutorily required for an LLC. LLCs, we can get away with kind of just running this bare bones, simple. That's why when we're looking at the cost of the LLC, we're really looking at, in California, that $800 LLC tax and not too much else. Maybe some licenses, maybe some the cost for the statement of information filing that occurs every year. There's a couple of requirements, but very few. And that is all separate from, so I'm just looking at the cost of corporate governance or LLC governance, managing the business structure itself. And this is all separate from actually running the rental property, the costs of all of that. Other things you'll want to consider are, once you form the LLC, all of the contracts that you have set up with as you as an individual, whether, so let's take, for example, it's an existing rental property. So what happens to your rental agreement with your tenants? You'll want to reissue a new rental agreement with the LLC. You will be contracting through the LLC. Typically, you'll also want insurance policies to be directly held by the LLC. And then in theory, that insurance policy should cover the owners of the LLC itself. You may need to expand coverage for certain additionally insureds, depending on your structure. But usually you just want to make sure any contracts that went to you as an individual are now shifted to this LLC that you formed, because you have to treat the LLC as a separate legal entity, meaning you also need a separate bank account. So if you're used to just running money through your own personal account, that's where the liability will pierce right through. You'll need a separate bank account because you are running your all of the finances directly through that LLC's bank account. You are welcome to take distributions, and I like to counsel clients directly on the best way to take distributions, because what we really just want to make sure we're doing is not treating this LLC is as our alter ego. It has to be a separate legal entity. Okay. All right. Now I want to get into a couple more topics, and then hopefully we can wrap it up and handle some quick questions at the end if there are any, if we have any time left. So I'll try and move a little bit quicker through this. But we do have a couple of heavy tax sections coming up. So I'll try not to get too detailed, and we'll stay a little bit high level. Some of the other considerations that you'll want to look out for when you're setting up an LLC for your rental property. Do you have a mortgage on the property? One of the biggest, it's a huge flag that never actually gets implemented, I'll say. There is often lenders put in a due on sale clause in their loan agreements. So if you have a mortgage on the property that you're renting out, there is a good chance that there's a due on sale clause. Transferring that property into an LLC, technically, from my perspective, not a sale. However, it depends on what their contract says, because oftentimes just moving that property into an LLC will trigger the due on sale clause, which means that the balance of your mortgage can be accelerated at the choice of the lender. That's a huge underscore, at the choice of the lender, because I personally, and I, in consulting with plenty of other attorneys, have with many years of experience in this industry, have never experienced a lender actually enforcing the due on sale clause. However, it is there. So you do not want to put yourself in a position where at their choice, they can sort of just say, okay, you owe the entire balance of the mortgage right now, or, whatever the term is, 30 days, 60 days, 90 days. So that's one to look out for. You're kind of gambling at that point. I can't really advise clients to directly be in a position where that clause could be enforceable, though I have never seen it enforced in practice. So it's a big concern. Not all loans and lenders are going to require this due on sale clause. They won't all be in your mortgage contract. However, they could be, and they could be enforced contractually. It kind of just depends on what they say and then how the lender feels. I never want to put a client in a position that could cause that risk. So look out for that. You could try to find a more favorable lender, though it's a sticking point often. Okay, let's see. What else do I want you to take away that we haven't already covered? Actually, great point on this slide. So we've talked about a a lot of unique structures, but we really haven't talked about them yet in the context of your revocable living trust or whatever trust you have. So your revocable living trust, its primary intent is to avoid probate. How is your revocable living trust treated from the IRS perspective or from a legal perspective? Generally, not any different than you. However, if you want to avoid probate, you on this asset being the LLC membership, not the property itself, because we deed the property into the LLC. If you want then this asset to be protected from probate, there's a couple things we can do. So there's two very common methodologies here. One being to just set up the LLC with the members or owners being you as individuals, and then assign over that asset, the LLC asset, into your trust. That's one way. There's another way where you can also have your trust, your revocable living trust, as the direct member. But then you'll want to make sure that you'll often want to make sure that you have then yourself as an individual as a manager of that business. So there's a couple of different ways to go about doing this. Typically, we try to stay pretty simple, honestly, and do an assignment. And our large estate administration team has had no trouble enforcing that, because really what we're trying to capture is the intent. For the probate courts, we're trying to capture that you've passed away, you had the intent to transfer this property, this asset, this LLC interest through your trust. So that's what we're looking at. Now that's a revocable trust. It's entirely different if we're talking about irrevocable trusts, and you're probably talking with a lot more advisors if you're talking irrevocable trusts, because irrevocable trusts are treated extremely differently. From the IRS's perspective, they are separate from their trustees, because essentially with an irrevocable trust, fundamentally you're giving that asset, you're taking it off of it's entirely separate from you as an individual. Think about that irrevocable trust as its own person. Also think about the LLC as its own person. These are separate legal entities. So for an irrevocable trust, treated very differently, but things to consider, because sometimes we find that if part of this LLC membership interest transferred through a state administration and transferred into an irrevocable trust, perhaps your parents had an irrevocable trust set up for you to receive your inheritance into. We do this frequently for our clients. Then that LLC membership interest is going to be held by an irrevocable trust. There are many, many different considerations to then look at. So really, that's why it is so critical that you talk to an attorney and advisors on your specific situation, because it's not a one size fits all. And that's where I caveat DIY LLCs or online services that don't ask all of the necessary questions when you're looking at, how do I need to structure my LLC? How do I need to do this to make sure that I'm not facing adverse tax consequences, exposing myself to liability, any number of things. These online solutions or do-it-yourself solutions are just not going to look out for you the same way. So we strongly, strongly advise you to get actual financial and legal counsel that's looking out for you in your best interest. Okay, we've talked quite a bit about taxes, but there are some concepts that we haven't gone over. So, real quick, I'll just say, when we're transferring property into an LLC, just like simple, if it's, say you own it wholly as an individual, you want to transfer it into an LLC, or you own it with your spouse, or you own it with your sibling, 50-50 or something, and we're transferring it into an LLC. As long as the LLC has the same proportionate interest structure, meaning if it's you as an individual owns 100% of the property and you as an individual owns 100% of the LLC, or you and your sibling own a certain percentage and you and your sibling own the same percentage of the LLC, that's a proportionate interest transfer, and it saves us from a couple of things. So it saves us from triggering reassessment, and it also saves us from the transfer tax. So, for example, California has a general transfer tax of 0.11%. Sure, that's real small in a percentage, but when you're looking at the property values here and the fact that, a single property can be easily 1 million, and then you're looking at another over $1,000 just unnecessary tax because you transferred that property not proportionately, not great. We could have avoided that. So get some help with the planning. And then you're also going to want to do a lot of considerations around capital gains tax and how that property is being transferred. So generally, you may be very familiar with the fact that when you inherit property, generally you get that step up in basis. Typically for simple LLCs that have rental properties, especially that where it's just, owned as community property by your parents pass away and then it goes to you, you're going to get the same step up in basis typically, but there may be some additional considerations, so you want to be careful. But typically, especially if it's a disregarded LLC, let's say your parents are transferring an LLC directly to you, then that property will get the step up in basis still. Now let's think about it the other way around. Say your parents didn't bother to set up an LLC, you get the property, then you put it into an LLC, a little bit less complex. You still get the step up in basis when it transfers to you, but just lots of considerations to have. And then you'll also want to think about, like I said at the beginning of this, what do you want to do with that property? Do you actually want to keep it? Do you want to get rid of it? When did your step up in basis happen? And what is your capital gains tax risk, essentially, liability now? And what will it be in the near future? To kind of consider, okay, do I want to change assets or do I want to keep this, set up an LLC, put it into the LLC? Um, and then I won't even get into 1031 exchanges, but just there's plenty of things when you're thinking about changing property. Talk to either one of us or a tax professional, someone to give you real guidance on how to best do that. There's a lot of, especially in our department, we can help you through some of these decisions and get you at the most advantageous planning just based on whatever your goal is. Okay. Um, I'm probably going to cruise through the rest of it because I think I've covered in one way or another most of the remaining content, but I'll walk through it just to make sure that it sinks in. So oh, and actually, sorry, one more comment on taxes and as far as reassessment too. Because this one under Prop 19 is a big one. Um, so before we kind of cruise through the rest of the slide, I do want to cover this. So generally, now that we don't have, or now that Prop 13 has been substantially replaced by Prop 19 in the state of California, any home that's not a primary resident isn't going to get that parent-child transfer benefit. And so it could be and likely will be subject to reassessment. There's a lot of other when we're looking at investment properties. Now let's think about, okay, was the property your parents' primary residence and now you're transferring it? If you decide to make it your primary residence, huge if, first off, do you actually want to move? If you decide to make it your primary residence, maybe you can avoid reassessment. However, mostly what I see is, there's opportunity for reassessment on the second homes or the inherited homes. What I'm most concerned with you taking away from this is actually the the LLC rules around Prop 19 and this interesting sort of legal creation here, where there are two different rules that a property within an LLC could fall under as far as when it gets reassessed next. So, really high level, when a property enters into an LLC in um, in a change of ownership that was not subject to reassessment. So let's say I, because it was a proportionate interest transfer, me and my sibling transferred into an LLC, a property that we both owned 50-50, not subject to reassessment then, so falls under what is called the change in ownership rule. This change in ownership rule means that when more than 50% of the property changes ownership, then reassessment is triggered. So what does that look like if it's just me and my brother? It means that if my brother passes away and his share of this LLC membership interest that holds the property, so 50%, let's say, keep it simple, 50% is transferred. That's not more than 50% of the property that has changed, but the moment that it becomes more than 50% of the property has changed ownership. So that LLC interest goes to his kids, perhaps. Let's say I pass away, my LLC ownership interest goes to my kids, my beneficiaries. At that point, then you have more than 50% of the property has changed ownership and now is subject to reassessment. That's the change in ownership rule, which only applies if the LLC takes in that property and in that acquisition of the property, there's no reassessment. Let's say, alternatively, you set up an LLC because you're looking to invest in more property. You set up the LLC to buy a wholly new property entirely. This falls under a completely different rule for reassessment and can actually be very advantageous to elongate almost indefinitely the reassessment of that property. If a property enters an LLC in a transfer that is subject to reassessment, meaning when it goes into the LLC, it gets reassessed. A sale of a home, great example. LLC buys a home, property is reassessed, property tax is set. So now, when more than 50% of that LLC is owned by one individual person, only then does the property get reassessed. So at that stage, if you fall under this change in control rule, different from the previous change in ownership rule, if you fall under this change in control rule, you could, in theory, maintain the LLC ownership to a point where no person or entity has more than 50% and therefore doesn't have complete control over, and the property doesn't get reassessed at any point, as long as that percentage stays. So interesting stuff, things you really have to plan ahead for, and a lot of pre-planning and a lot of I cannot advise you to go through with some of this planning without consulting with a professional. So please do feel free to reach out to us or another attorney. Please work with an attorney and a professional who knows these laws and can help guide you through how to do this. But some interesting things. Okay, so we've kind of talked about everything. We talked about the California LLC tax, that $800 annual tax. We talked about property tax when you get reassessed, capital gains, step up in basis. Lots of considerations around what you want to do with planning for this property in the future, and then also what your taxes actually look like depending on the LLC membership structure, the ownership interest of the LLC, whether or not it's a disregarded entity because you own it or you and your spouse owns it, or whether or not it's a partnership or a pass-through entity because you own the LLC with one other person or multiple other people, but in a partnership structure for tax purposes. Lots of things to consider. Um, and all things that, this is meant to be the high level, and then talk with your attorney and talk with your tax advisor about what makes the most sense for your particular situation based on your assets, your anticipated assets, and your end goals. Okay. Um, I think so that's really what you want to account for. Your long-term goal alignment. Plan for what you want with what you have and what you anticipate having. We have to use all of these different benchmarks to create the appropriate plan for you. All right. So just keep these in mind as you're thinking about all these heavier concepts. Am I triggering anything that would create a change in my circumstance that would require planning? Or am I anticipating? Am I retiring? Are my parents looking to get rid of the responsibility of their existing second properties? Am I purchasing a new property? All of these types of things are stuff you need to stay updated on. We create content at Copenbarger frequently, and when there's a lot of significant law changes, at a minimum, we publish it out to our client base, but we also push out our seminar content and additional webinars on specific topics that help you stay updated and help you know if there's significant legal changes, like when Prop 19 hit and our kind of world as we knew it blew up. So we had to start operating under a completely different framework for advising clients. Those changes are rare but happen. You'll also want to consider, like I was just sort of mentioning, when do you want to give up control? Are you at a stage in life where you would like your kids to start stepping in? Rather than gift them the property and cause all of those tax implications, it may be more advantageous to give them management control through an LLC so that they can start to manage the properties and investments for you, but not transfer the actual assets, because then that will trigger tax consequences and also mess up your long-term planning, because you may not be able to take advantage of the step up in basis. You may not be able to take advantage of some of the interesting tax advantages that are set up if you do too much planning in the wrong direction, I'll say. So all things to consider in this legacy preservation. Oops, skipped a little too far ahead. Um, what um, what other things do you want to consider? So once you set up the LLC, I do want to say, once you set up an LLC, there are very few requirements to keep it up to date. As long as you're running your contracts and your bank account through the LLC and you're doing all of the operations as you need to, there's very few requirements that are ongoing. But laws can change over time, and so you really want to just stay ahead of the curve and keep in mind that we publish regulatory updates. For example, the FinCEN updates that have been quite a roller coaster and now are kaput. That was a business requirement for even all of our small rental property LLC businesses, uh, and now is no longer. But sometimes we see regulatory changes for businesses. We always keep clients apprised of the ones that will sort of impact everyone or impact most of our clients. And then for more specific counseling on your specific situation or your specific state even, come to us and we can discuss, okay, where are the gaps? What do we need? Do we even need additional advisors outside of our scope too? We can help step in and really guide you in the right direction too with some of these regulatory updates as well. All right. Well, I have said quite a bit about our team already, but just keep in mind, I talked about inside the state of California, outside the state of California. With this type of content, a lot of it can be that, as business attorneys, we can form LLCs in other states without any issue. You can still get all of that help in-house at Copenbarger. You can also get all of your estate planning integrated in with that. Now, that is state specific, so you should be a California resident if you're looking at setting up a trust for your estate planning. But please do come to us because we can often provide a ton of advice and guidance and let you know where our limitations are and if you need additional external resources, whether it's other attorneys or other types of advisors. We'll kind of fold those into our process and make sure that you're taken care of. Okay, now that's it. Finally, you stuck it out, and we did go over time. So I'm probably not going to get through any of the questions that came in. But how about I'm going to leave this up here for you to submit an evaluation. Just we strongly encourage, whether you have good things or bad things to say, we want to learn what you need, what you benefited from, and what you didn't benefit from. If there were any issues, we want to be able to help you to the best we can. So please feel free. Please leave. We live and thrive from our evaluations and our client feedback. Please give us feedback to help us tailor to your needs. So I'm going to leave these links up here, and then what should be populating in the chat or already has, it looks like, is the link to the digital evaluation. If you have any questions, you can always email us at info@copenbarger.com, call us anytime, or visit our website. And then we have a ton of social media presence. Excuse me. So I'm going to leave this up here for you to complete the eval. And while you're doing that, I'm just going to field and see if we have some questions I want to cover that maybe we haven't touched on fully, or maybe I want to reiterate. Okay. Let's see. Okay. So sorry if this is distracting, mute me if it is. But for everyone else, I have, if the property is in the LLC, does that mean it's not in my trust? Okay, so we covered this a little bit, but let me make it clear. So what we do, let's say you have already, your estate planning is already done and in place, meaning that your properties have all been deeded to your trust as well. So even your primary resident and your secondary resident, all of your homes have been deeded to your living trust. What do we do with the property then when we're creating an LLC for it? We're taking it out of your trust to put it into your LLC. But in one way or another, we're putting that LLC into your trust, whether it's through an assignment or whether it's through having your members directly be your trust, and then so the owners of the LLC are structurally they're your trust. So it's created in a way where your trust already owns the LLC. So that's essentially what's happening. We're taking it out and creating this LLC layer. So property, LLC, trust is kind of the layering order. I hope that clarifies it. Okay, this looks like this one came in earlier and we did cover it. So my daughter doesn't own the property, but I want her to manage it. What should I do? So a couple things we talked about. You can either make her an external manager of the LLC, meaning she's responsible for the LLC itself, Or you can make her sort of more of an employee if you really want her to be a property manager, if you really want her to take on a full role of property management. So there's a couple of different things. And then if you're running that LLC as a property management LLC, then you'll want to consult your tax person and see if there's not additional deductions that you can get from registering it as an S corporation. If you create the LLC, you can either register it as an S corporation at the beginning, or you can do so later down the road. There will be some implications, but generally it's pretty flexible that you can change that and designate it as an S corporation to get some of those tax benefits if there are any. Okay, and then one last one. Um, how much does how much does setting up an LLC cost? And what's the ongoing cost each year? Okay, so for us, this is going to vary a lot because you're thinking about legal fees and you're also thinking about the actual registrations and filings and whatever additional specific costs there are. Luckily, so what I'll say is come have the consultation with us. We'll kind of map out what the structure will look like. And depending on the structure is usually going to make the cost vary. And we do Copenbarger for almost all LLCs, especially this type of LLC, we can offer either flat fee or billable rate um, to your liking. So we can really kind of specify with this structure, it can cost you this flat fee. And that's usually pretty clear to clients. Um, Keep in mind, okay, and then what's the ongoing cost each year? So keep in mind some of the ongoing costs that I already discussed. You'll be required to, in the state of California, it's going to vary state by state, but in the state of California, you're going to be required to pay the $800 LLC tax. There is an additional LLC tax if you have more than $250,000 dollars in annual revenue under that LLC. It's a scaling sort of tax. It never goes too much higher than a couple $1,000s, but keep that in mind if you're really bulking tons of property into one LLC. Something to consider that, that $800 is the floor, as I mentioned at some point. It can go up, but it's rare that we'll have clients in a situation where we'd advise them to create that much liability in one LLC and not kind of distribute the liability there. So keep that in mind. That's going to be the annual tax that you'll face. There's also the statement of information filing that you'll have to do every year, every other year for LLCs. And then there may be some local licenses with your city, your county, depends. Those are usually the fees. You may have also a little bit of a couple of additional fees to have a registered agent in the state of California that's separate than you. Doesn't have to be separate than you, but I usually advise that. You may have us be your registered agent. It's essentially a legal obligation or an obligation to receive certified mail or service of process and be available, have an individual in seat to be available to receive mail at all business hours. So some additional minor costs, but really the big ticket one is going to be the $800 a year franchise tax. Okay, that LLC annual tax. All right, well, I've spent enough of your evening, and hopefully you could take away plenty from this, maybe too much. And I hope you all have great dinners planned and enjoy the rest of your evening and 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 come back for our next webinar. Please go ahead and set up a consult with us. We're more than happy to talk with you about your specific situation and give you some advice. All right. Well, thank you. It was so nice talking to all of you. Thanks for sticking in for this longer webinar than expected. Thanks. Have a good one.